All right, welcome back. So our next panel hits on both of the key areas of focus of the SEC's cyber unit: cybersecurity and cryptocurrency, regulation, enforcement, litigation. So what area of securities regulation has experienced such attention in decades as crypto? And the SEC Enforcement Division has been on a tear in its enforcement efforts in that area. Then, of course, cybersecurity also continues to be one of the most pressing and quickly evolving areas at the SEC and in the law generally. So who better to moderate this panel than Liz Gray of Wilkie, Farr, where she's a partner and co-chair of the Securities Enforcement Practice Group. Her background is really interesting. Liz served as a senior official for 12 years at the SEC in the Enforcement Division, also in the Division of Corporation Finance, and also as a counselor to Chairman Levitt. But also, Liz has a unique business perspective on legal issues. She was general counsel and COO of a company called Comprehensive Neuroscience, was also the founder and the COO of Gabriel Pharma, an early stage biotech company. Welcome, Liz.
Thanks, Bruce.
Luke Cadigan is our next panelist. He's a partner at Cooley. Luke was formerly a senior official in the Enforcement Division in Boston, serving as an assistant director, a senior trial counsel, and also as a member of the FCPA unit. Recently, Luke has been quite active in the cryptocurrency practice area, so he's a great fit for this panel. Welcome, Luke.
Thanks, Bruce. I'm glad to be here.
Anthony Ferrante is a senior managing director and the global head of cybersecurity at FTI Consulting. His experience is truly remarkable. He previously served as director for cyber incident response at the U.S. National Security Council at the White House. And before that, he was chief of staff of the FBI cyber division. He's a true expert in the data privacy and cybersecurity field. I encourage you to check out his full bio on the website. It's really remarkable. But I will add that last year, on top of everything else, Anthony summited Mount Kilimanjaro. So welcome, Anthony.
Thank you, Bruce. You're very kind.
You're welcome. Finally, from the SEC, we have Littman, who is the chief of the SEC cyber unit. So exactly the person we need and want here today. The cyber unit, if you aren't familiar, is the agency's national specialized unit. It focuses on cyber and crypto related misconduct. And she's been at the SEC since 2010 and took over as the head of the cyber unit in December of 2019. So we are all very interested in what the cyber unit is focused on, what they're up to, and very interested and eager to hear from Kristy today. Welcome, Kristy.
Thanks, Bruce. Happy to be here.
Liz, let me turn it over to you.
All right. Thanks, Bruce. Great to be back and to have such an interesting group of panelists here. So we're going to start with cryptocurrency. It has emerged as a major innovative force in our financial markets, and the SEC has been challenged to fit it into the regulatory framework that the SEC has. That framework certainly wasn't developed with cryptocurrency in mind. But the SEC is very good at taking old laws and applying them to new circumstances. And the Enforcement Division has really done a tremendous job pursuing, as Bruce said, a lot of cases this year involving cryptocurrency. And congratulations, Kristy, on growing such a robust program. The cases have touched on initial coin offerings and whether they are should be registered securities offerings. They've also touched on fraudulent offerings. So, Kristy, we'd love to hear what you view as sort of the program's priorities and your overall sort of vision of the enforcement program involving cryptocurrency.
Great. Thanks, Liz. First, of course, as a government employee, I have to give my standard disclaimer, which is that the views I express today are my own and do not necessarily reflect the views of the Commission or of my colleagues on the staff of the Commission. Now that we've dispensed with the formalities, I think, when I think about the SEC's enforcement priorities in the cyber area, one thing we're always mindful of, and I guess this is true beyond the Enforcement Division, is encouraging the use of new technologies for capital formation. And so in addition to the cyber unit's enforcement efforts in this space, the SEC also has its strategic hub for financial innovation, FinHub, as we call it at the SEC. And they're a group of, it's kind of an interdisciplinary group. It has delegates from all the different divisions and offices of the agency. We meet bi-weekly internally. We meet frequently with the chairman's office. And they have really an open door policy to engage with industry as well. And so they're often holding peer-to-peer meetings with folks who have innovative ideas that they want to discuss and come in and get input from the regulatory divisions. I don't attend those, the peer-to-peers. I don't think most of them want to talk to enforcement at their development stages. Most of them probably not like to talk to enforcement at all. But that's just to say that we really do encourage the use of new technologies in capital formation. But of course, the enforcement division comes in because when investments are available to U.S. investors, the issuers of those investments have to comply with the U.S. securities laws. And so that has become an important area of our focus and a specific focus for the cyber unit. We are very active, both in the unit and in the regional offices. The unit has a presence in several regional offices in New York, Philadelphia, Chicago, San Francisco, and LA. But we also have plenty of folks in the regional offices in the core groups and in the home office in our core groups who are engaged on these issues and who are interested in pursuing cyber cases. And so you may engage with those folks as well if you're practicing in this area. The types of cases we're focused on is specific to the cryptocurrency space. I know we'll talk about cybersecurity a little bit later. But in the cryptocurrency space and the kind of digital asset space, we have essentially three buckets. One is the fraud bucket, and that is an area where I think we'll probably continue to see plenty of cases. Blockchain crypto has emerged in some manners as a new avenue for some of the traditional frauds we've seen. Ponzi schemes, multi-level marketing, things like that. Some of them, are just kind of avenues for folks to separate investors from their money. Sometimes, though, you may have a fraud case that doesn't involve misappropriation or misuse of assets, but just involves misrepresentations about the business or the offering. So you may see us pursue fraud charges in those instances. And then there are the non-fraud registration cases, which we've had a fair bit of success in. We've had a couple litigated cases that have come to fruition with really favorable rulings out of district courts for us. And we continue to pursue non-fraud registration cases, although I will say on that front, I have seen anecdotally kind of an increase in compliance. I've seen quite a few instances where we'll see coverage of something in the press, or we'll pick up on something that is being offered, and we'll call and we'll engage with counsel, and sometimes we'll hear that they're taking advantage of an exemption, or they're really trying to take measures to comply with the federal securities laws. So I do think that's a positive development in the space. And then I think the third bucket in the digital asset space is what I call digital asset adjacent activity. So this is other activity that requires registration, like if you're running a broker-dealer or an exchange that deals in crypto or in digital assets. And then kind of related to that as well are promoter charges. So ICOs seem to attract celebrities, and so our co-directors put out a statement kind of at the height of that just put folks on notice. If you're going to go out and tout these digital assets, you have to disclose the compensation that you're receiving. And so we've brought a few cases in that realm, and we'll continue to the extent that we see that conduct. So that's the priorities. One thing I'll note is that when we're looking at digital assets and we're considering whether something is an investment contract and a security under the Howey test, that we really look at the substance of the transaction or the offering. That's what drives our analysis. We're not kind of looking at what the name or the labeling that's on the offering. We really are looking at the underlying substance to try to get at whether we think that there's an investment contract present.
So what do you think are some of the most critical cases, most important cases that you've had, that you've brought?
Well, I alluded to the litigation, and I'll talk a little more in depth about those in a minute, and I think they tend to get a lot of the press in this space. But, I want to point out too that we have a lot of settlements that are in standalone Section 5 cases that provide a really nice balance, and I think are notable for that reason. They allow the companies to continue their entrepreneurial efforts and their innovation while also giving investors the necessary disclosures through registering the token. So this is what we call kind of colloquially the Airfox Paragon model, and those were the cases that debuted this model, but quite a few respondents have settled to that model since then. And the idea is they come in, they pay a penalty that is calibrated with recognition of the undertakings that they're agreeing to. And those undertakings are registration and a claims process. So they register the token that satisfies what's really missing when you conduct an offering without registration, which is disclosures to your investors. So once that registration is complete and the investors have the disclosures that they need, then the companies will undertake to offer a claims process to investors. And that just gives them a chance now to make an informed investment decision. Now they've got the disclosures, they can make that investment decision. Do we want to go in and make a claim and get our money back? Or do I want to stay invested and continue to invest in this innovative technology? And so it's kind of a model for those companies to come into compliance. So I do think that those are meaningful and significant in the cryptocurrency space. And I'll note, there's in the fraud space, there certainly is a focus at the SEC on returning money to harmed investors. And so there are quite a few cases where we've been able to go in and freeze assets or get a receiver to go in and take control of digital assets and return those assets to investors. So those are particularly meaningful for investors as well. But from a legal precedent perspective, I think we have to talk about Telegram and Kik. They're also my favorite things to talk about. So those cases both proceeded in the litigated manner, and they both yielded judicial opinions that are very clear on the question of whether these ICOs constituted Section 5 violations. And in Telegram, I'll start with Telegram. It came first in time. That was a case where we had gone in and gotten a preliminary, first we went in and got a temporary restraining order in advance of the distribution of the tokens. So it's a little different from most of our cases in that the tokens were not out in the marketplace yet. We went in October of 2019, got a temporary restraining order, conducted discovery at lightning speed, and ultimately had a preliminary injunction hearing in February of this year, received an opinion in March where Judge Castile in the Southern District of New York provided a very thorough analysis, including an analysis of the exemptions that were asserted in that case. And there, the judge really looked at the economic realities of the transaction. Telegram knew that its purchasers were not going to pay $1.7 billion just for a means of storing and transferring value, which was the stated purpose of the grams. The grams were the token at issue in that case. Instead, the court determined that Telegram necessarily had to sell the initial purchasers a token that they could resell, and they would be looking to do that for maximum profits. That was the objective. To do that, to maximize their profits, Telegram had to remain committed to the success of the blockchain after its launch. And so those are, we're kind of ticking off the prongs of how when we walk through that. And the judge found that ultimately that was an illegal scheme to resell the grams into the public market. And again, that was a preliminary injunction standard that this opinion was issued under. So the opinion found that we'd proven a likelihood of success on the merits, and then ultimately we reached a settlement with Telegram. Kik was the next, and I shouldn't say those are the only litigated actions. We've had other litigated actions. Most of the others, or all of the others, really have fraud components to them. So these are the two that are standalone Section 5. KIC was another case that we filed litigated. And this one, we got through discovery and made it to the summary judgment phase. And so the opinion that we received there was the summary judgment standard, and it resolved the case on the merits, finding that KIC had indeed violated the law. And Judge Hellerstein, also Southern District of New York, took a pretty similar approach in looking at the economic realities. And he found that the undisputed facts showed that KIC offered and sold securities without registration or exemption, and that was a violation of Section 5. Looking at the economic realities, the court found that the KIN token, which is the token at issue in that case, would really be worthless without the promised digital ecosystem that KIC was marketing in its efforts or its discussions with investors, and found that KIC necessarily was the primary driver of that ecosystem. So again, just ticking off the prongs of Howey here. Helpfully, that opinion also included an integration analysis. And this is something I think, in my experience, we talk with defense counsel about in a fair number of cases, because quite a few issuers have done this model where they conduct a pre-sale using a SEF, and then they have a public sale. And the court just did a really nice job of walking through the integration analysis there and found that those sales were integrated and that constituted an unregistered offering of securities. And then KIC also asserted an affirmative defense that the term investment contract was being applied unconstitutionally vague when applied to their case. The court dismissed that finding and essentially just stated that the law in this area provides sufficiently clear standards. And then ultimately on the remedies piece of it, we reached a resolution.
So Luke, as a practitioner in this space, how clear do you think the guidance is for your clients in terms of whether you need to register your offerings or you have an exemption to take advantage of?
Yeah, and actually, let me start off by, we represented KIC in that matter. And I think some of the things are important to put in proper context.
Okay.
It's easy to look back now with the benefit of hindsight 3 years later, but at the time that KIC entered into its offering, the SEC really had, provided no guidance to the industry. There was the Dow report, which I think those of us in the industry thought, well, that was pretty clearly a security. You're taking a part of you were rewarding investors with portions of the entire project. And so that didn't seem to be something that KIC thought applied to it. Going forward, again, the SEC brought an action against KIC on the offering. Again, not for fraud, but simply for registration purposes. The project since has, been exactly as had been contemplated, namely a very useful project. It's got the third most activity for a token outside of secondary trading. And the SEC did not bring any action against its current activity. So we're only focused on whether at the time it should have registered. And again, Judge Hellerstein decided one way. We would welcome the opportunity for the Second Circuit to address those issues of common enterprise and reliance on the efforts of others. However, the resolution the staff offered KIC gave KIC the chance to move forward. And that's all KIC ever wanted. To a certain extent, we appreciate the opportunity to move forward. It's a shame that we had to go through a lengthy and costly investigation and litigation to get to that point. In terms of clear guidance, I think that we're still looking for clear guidance, and we're here with Kristy, and I think she's fantastic. But enforcement, to our thinking, is not the tool for making regulations. And if there's a message to be sent, we've often thought that Commissioner Peirce's approach to this has been a better approach to taking into account the desires of the industry and providing real guidance. And I was wrong 3 years ago when I thought that the clamor for leadership and guidance in the space would force the SEC to take action here, and really done very little other than bring enforcement action saying, no, this is what you can't do. But doing very little to say, here's what you can do, at least publicly. And in that context, they have put forward, a 38 framework of 38 non-exclusive factors, and they put forward 2 no action letters. But the no action letters are areas, and again, I'm not just saying it for me, but I mean, this is something that Commissioner Ferrante has said, provide very little guidance because they're area things that few people conceived of to be securities. So I think that it's pretty clear that the SEC has taken a very negative approach here, but the question is, is there any affirmative guidance, to be provided? I mean, and by that I mean not only in the cases where the SEC has brought matters, but there have been a number of projects where either the SEC has looked at something and then not proceeded in some of my cases, and we appreciate the staff doing that, but then they've provided no public guidance to say the reasons why they didn't go forward there. And then other cases in which there's been tacit acceptance of projects that are out there, many of which are very active at various stages, and yet one does not know where the staff is going to go with those projects, whether or not they're going to treat those things as securities or not, because the tests that they're applying can be very subjective. So I would say that again, I think that there's still, notwithstanding the enforcement actions brought, there's still a need for clear guidance in this space.
Have you found FinHub to be helpful in terms of having discussions?
And it really depends upon the project, I guess. I mean, and all we can look at is in terms of what is out there. For all the talk that we hear about, come on in, we're here to help, or the government, we're here to help. We'd love to talk to you about your projects. We've seen very little publicly in terms of the staff, FinHub, blessing a project, as something that, other than saying that it's a security, and you have to go through all the registration and treat it as a security, which may be ultimately where the SEC wants to be in this space. But in terms of figuring out a way for these token projects to go forward without being treated as security, no, we haven't seen anything, and in our interactions with FinHub, we haven't seen anything to suggest that there is a path forward. And again, we think in the industry that the concepts of decentralization and utility really go against the concepts of a registration regime.
You mentioned Commissioner Person, her point of view here, and it's really, having spent most of my career as in the SEC realm, it's very interesting to see a commissioner actually dissent from an enforcement settlement, to actually come out and say, I just don't agree with that. Usually that's sort of done under the umbrella of a private commission meeting. So she clearly feels very strongly about it. And one thing she has suggested is a possible sort of safe harbor, a period of time where companies have the opportunity to do these offerings. Luke, do you have a reaction to that proposal? Do you think it's realistic? Do you think it would be beneficial?
Well, actually, and first of all, let me just say that Commissioner Purse has been a tremendous comfort to us. I mean, frankly, for our sanity, if no other reason. I mean, when we make these statements around the lack of clarity and the demand for this, and that these, the no action letters and the framework, do not provide clear guidance, one could take the position that we're just, sour grapes out here. But when you have a commissioner saying the exact same thing, it gives you some comfort that at least you have your concept you think is right. In terms of the safe harbor, yeah, no, I think I think that the concept that she has in place is a fantastic one, because it truly appreciates the innovation, in this industry and the potential benefits, but understands the concerns of those in the industry. How can you create, a truly decentralized utilitarian network out of nothing? And how do you, and again, the standards for, the level of decentralization and utility are so high. So what can you do in that interim time? So I think that her concept is realistic in the sense that it would be realistic if the staff were to adopt that, or at least have the discussion, which is all they really wanted. Rulemaking discussion around public discussion around what would be the appropriate way to go about things. However, and I do think that would be realistic if we could have a framework like that. However, I think sadly I don't know that it is realistic at this point for the SEC and the staff to engage in such a proposal, because to a certain extent, it would mean having to admit that it could have done so all along and had this discussion. So, and until the SEC and staff gets behind this proposal, I don't think it is realistic.
Yeah. Christy, one thing I noted in the two very critical cases, the offering cases, Telegram and Kick, and really a success story again for you, the settlements are quite different. Telegram has a large disgorgement component and Kick does not. Can you speak to that to try to give some, shed any light that you are able to for those of us on the outside?
Sure, and then I would want to kind of respond a little bit to some of the discussion you had with Luke as well around the safe harbor and those types of cases, or those types of plans. The Telegram and Kick settlements, though, they are different. They're similar in a lot of ways. They both, in both cases, the defendants were enjoined from future Section 5 violations. And both included a monetary component, and they each included a conduct-based injunction that was really tailored to this type of case. And because we have that Section 5 injunction there, the conduct-based injunction allows us to kind of ensure that they're complying with the injunction from future Section 5 violations, and that the conduct-based injunction requires them to give notice to the SEC of future digital asset offerings. And in the case of Kick, there's an additional term to the conduct-based injunction that they also have to give notice if they want to sell the 3 trillion KIN that they retained in that case. That wasn't a concern in Telegram because they hadn't actually distributed the grams there. But they do differ. I think the primary distinction is the monetary relief. So the both by amount and the characterization of that relief. Telegram agreed to a disgorgement amount that was satisfied by returning money to investors, and then they paid a penalty on top of that amount. Kick's monetary relief was fashioned entirely as a penalty. And there are a few reasons for that, but I do want to be mindful of sticking to information that's publicly available. So one important thing to note is that the procedural posture was a little unusual. We received the summary judgment opinion with a pretty tight deadline to brief remedies, and the judge's directive was, and there was a lot of back and forth briefing in this case. I think the judge probably had heard all he needed to hear from the parties in Kick. But he gave us essentially a 3-week timetable to either come to an agreement on remedies or to separately brief what we thought remedies should be. And so there wasn't really an opportunity to conduct disgorgement around, or to conduct discovery around what a disgorgement figure would be and try to come to a reasonable approximation of the ill-gotten gains. And so in our discussions, or in our settlement, we characterized it entirely as a penalty. And, as with a lot of penalties, I think our priority is preserving and obtaining as much as we can for the harmed investors, where we're going to conduct a fair fund. And that is a case. Kick is the case where we're going to conduct the settlement contemplates conducting a fair fund as soon as we'll have to move the court for that, of course. But it contemplates distributing the proceeds of the monetary relief to the harmed investors. And so, when we're doing that, we look at kind of what we can reasonably expect to collect. And so we did conduct throughout the course of discovery, and this is publicly available on the docket, 30B6 deposition of Kick's representatives that gave us a sense of their financial condition. And so we really calibrated the relief there to get as much money as we thought we could reasonably collect and quickly preserve it and return it to investors.
Okay. And did you want to speak to the safe harbor?
Yes, thank you. I didn't want to interrupt Luke, of course, but I wanted to just highlight a few things. I mean, I know Luke talked a little bit about CorpFin's framework for analyzing an investment contract. And I think, I do think it's a pretty clear analysis that has applied to digital assets. And I think the Enforcement Division's action in this space have been very consistent with that framework and consistent with the existing statutes and case law. And so, I think the desire for a safe harbor doesn't necessarily suggest a lack of clarity. In fact, I think the need for a safe harbor, right, the call for one is really premised on the notion that this conduct is violative of the law. And so folks who are proposing or who are proponents of a safe harbor, what they're really saying is, hey, we want to do this and we want an exception, we want an exemption because this is not compliant with Section 5. And that's what the case law says, that's what the statute says. And so I'm not sure it's a lack of clarity as much as, and again, we've had these enforcement cases where the courts have found that they're clearly able to apply the law to this context, recognizing, of course, it is a relatively new area of the law, and so there aren't a lot of opinions, but the courts that have issued opinions have been pretty clear. And then the other thing I'd point out is that, what I hear Luke saying is we want to, what they want is to say these aren't securities. And I'm not sure that's the most practical approach. I think, and Commissioner Peirce actually outlined this in her February 2020 speech where she introduced the notion of a safe harbor, that there are lawful roads to take when a token issuer wants to issue a token that is clearly going to be considered a security. You can conduct a Reg A Plus offering, you can register, of course, you can conduct a non-US offering, you can comply with Reg D in your offering, you can release the first block and step away. There are ways, and for decades, people have conducted offerings, have raised capital compliant with the federal securities laws. And so, while this is a new area of the law and a new technology, there's no reason that you can't access the US capital markets or access capital markets generally and still comply with the federal securities laws.
Very different perspectives out there right now. It's so interesting. And, to be continued, we could spend hours talking about this. And we may come back, but I wanted to reach out to Anthony for a minute, who has this extensive experience in cyber, both through the government and now at FTI. Anthony, what are you seeing in this space? What are people coming to you with on the cybersecurity problems?
Thanks, Liz. I think it's safe to say this is certainly an emerging technology, right? It's cryptocurrency, just like cybersecurity, is more and more becoming more and more on folks' radar every single day. I think it was just a few weeks ago, the Attorney General released a cryptocurrency framework, right? An enforcement framework, which just highlights that this is becoming more and more of our everyday life. Cryptocurrency, just like cybersecurity, is a technology that really could fundamentally transform how we interact as human beings, right? So that's why it's more and more important that the use of this technology is safe and, of course, does not compromise public safety, of course, or our national security. And why that's important is because what it does is it enables a new form of crime or fraud, right? Especially these days during a COVID-19 times, never before has cyber crime been an important topic. The FBI just released statistics the other day that cyber-based crimes are up 400% from what they usually are, right? Which is an astonishing number if you think about it. But what's important is that cryptocurrency not only increases the risk of cyber-dependent crimes, but also cyber-enabled crimes, right? And it's important to differentiate between the two. For example, the FBI is seeing cyber criminals using cryptocurrency to prevent us from following the money, right? So asset tracing is becoming more and more important. Asset tracing through the use of following these cryptocurrencies on the blockchain. And that has enabled a wide range of investigations as well as the trade of illicit goods on the dark web, right? Don't forget, we have ransomware, we have extortion, we have theft of cryptocurrency, and we have crypto mining, right? A whole new slew of fun things for me in private practice to help my clients combat. But to your question, right, what am I seeing every single day? When my phone rings, it's usually two aspects, right, or 2 points that folks are calling me for. It's either readiness or response. Readiness is very straightforward, ensuring your systems are secure and using industry standards. Now that's a very gray area, right? Industry standards are evolving every single day. So those industry standards are industry standards right now. Many times clients will call and say the government is pursuing enforcement action. Can you help? They're holding me to a standard today, but this incident occurred 3 years ago and the technologies have changed so quickly. Please help. Of course. Then, of course, is the response aspect of the work that we do. This is when there's an incident, again, whether cyber dependent or cyber enabled, we help our clients recover from those incidents. At FTI, we're in a very good position to provide a holistic task force type response effort. We have technology experts, forensic accountants, and then of course a good friend of mine, Myron Marlin, from our crisis communications group, and who is also a former director of communications at the SEC. So every single day we're receiving these calls, and I will say that 2 years ago we received a few calls a week. Now we're receiving multiple calls per week across the country from clients. So it's clear that there's an uptick in these compliance and enforcement activities.
So interesting. And Kristy, do you think this is going to be, the cyber will continue to be an active area for the enforcement division in the coming year?
I do. I think, I think we are focused on a lot of the same issues that Anthony's dealing with. Although I'll say, we look at two impacts essentially of cybersecurity, one on regulated entities and one on public issuers and their reporting and their disclosures. With regard to the regulated entities, what we're really looking at there is whether they have cybersecurity related controls in place. So controls that are reasonably designed to protect customer records and information, designed to address risks of identity theft. If you're a Reg SCI entity, that requires you to maintain and review technology systems. And so when a regulated entity has been the victim of a cyber incident, we'll look to make sure that those policies and procedures are in good shape. And OC's in there looking at that stuff as well, kind of more proactively than reactively. And then we'll also look at, threat actors. So if we see that the purpose of an account intrusion or a hack is to conduct manipulative trading or to trade on material non-public information, we'll look into any suspicious trading in those cases as well. I think one point of emphasis is that, those rules that apply to the regulated entities don't require perfection. We're looking for reasonably designed policies and procedures. And, there's kind of a similar refrain for the issuer reporting. In that aspect, we're looking to make sure that disclosures of breaches and issues are with certain internal controls that are prone to cyber-related fraud. We're looking to make sure that those are being disclosed to investors timely and that those disclosures are fulsome. And we'll also incidentally look at trading in those cases too. A lot of times around a cyber incident that's going to be publicly disclosed, you'll see some trading ahead of the announcement, sometimes by insiders, sometimes by families and friends who learn of the breach before the public does. But again, we're not looking to second guess good faith judgments by the issuers. We understand that in many of these circumstances, the issuers, in most of them, they're the victim of a breach and they're working to get their arms around the incident. So, we are cognizant of that. And I think the number of enforcement actions we brought in this space probably is reflective of that general approach. But at the same time, we do have a responsibility to enforce the rules, particularly the rules that protect customer information and the disclosure requirements for public companies.
Yeah, I mean, I think it's so interesting because it's really shifted from, say, 3 years ago when companies were really just beginning to get their arms around how important this was, how important it is to have policies and procedures. I mean, what we've seen, sort of consistent with what Anthony was saying, is that there's also sort of a need to reevaluate the policies and procedures that exist because of the increase and the aggressiveness of the cyber intrusions that are occurring, particularly with COVID-19. Any other areas, Kristy, that you see your unit being particularly active in the coming year?
I mean, we'll continue to keep an eye on breaches or other cyber incidents and make sure that we think that disclosures are adequate or that policies and procedures are adequate. I mean, I think one thing that I'm particularly focused on is when you do disclose a cyber incident, making sure that it's fulsome and accurate. And I think one ask that I would make of the industry is to kind of continue to reevaluate the adequacy of your disclosures. In the two cases, that Facebook and Yahoo are kind of the preeminent cases that the agencies brought in this space. And in both of those, the risk disclosures were insufficient in light of the fact that the companies knew that they had experienced an incident, a breach in Yahoo and a misuse of user data in Facebook. But in both instances, they had risk disclosures in their periodic reports that contemplated a kind of a hypothetical. They said things along the lines of, we may be at risk of a security incident, and we might be at risk of user data being misused. And in fact, they were. In both cases, the company knew for 2 years that they had experienced one of these incidents, and they were still using disclosures that implied that they hadn't, and that it was really just a hypothetical risk when it was actually a reality for their company. And so, look at your risk disclosures, make sure that they're still in line with the reality of what your company's experiencing. As if you have a cybersecurity incident and you go out and you make a proactive disclosure, or you talk publicly to your investors about it, and you later learn that your prior statements are no longer accurate or fulsome, update them. Just kind of always be cognizant that, and we're cognizant that the issuers are still getting their arms around these incidents and trying to deal with a breach at the same time they're making their disclosures. But be cognizant that, if you've put information out there to your investors and it's changed materially, that you have an obligation to update that information.
Very helpful. We've got 1 minute left. I'm going to give Luke and Anthony a final word. Anthony?
Thanks. I was just going to echo what Kristy was saying a second ago. I think, she makes really good points. And the only thing that I want to foot stomp there is that when you do have an incident, don't go at it alone. Look for that outside independent expert to come in and do that fact-finding mission. She talked earlier about inadequate disclosures. Yes, those happen. Many times they happen, accidentally because you're not dealing with all the information. So that's why it is important to have that outside third-party expert who can come in, find those facts, and arm you, internal counsel, external counsel, with the information, so then you can make those informed decisions and make the notifications you need to make and not over disclose. Thanks.
Luke?
Yeah, nothing. Actually, just the only point to make is I appreciate Kristy's role in enforcement, and actually just going back to the cyber and the crypto again. The real big thing though is now we have an entire industry out there that's engaged in a lot of activity, and the industry there is trying to figure out, with respect to the projects that have passed IPO, what is the future for them, and what can they do? And again, that's an area where public guidance, clear guidance is going to be helpful.
Thanks. Great panel. Thank you all for doing it. And Kristy, thanks again for for being so open and sharing. And again, congrats on a great program.
Thanks, Liz.
Yeah, hey, thanks, Liz, and the whole panel. Crypto and cyber are topics that didn't even exist at this conference not too many years ago, and now they're just hugely important. So thank you so much for a great job. Next up at 10 a.m. is our first regulator spotlight of the day. It'll be a one-on-one conversation between Richard Best of the SEC and George Canellis. So thanks. We'll see you in a few minutes.